everyone. Thanks for joining us. We're going to wait another minute or two as folks get logged on, and then we'll get started. Hi, everyone. Thank you for joining us. We're going to wait just, I think, another minute. It looks like we still have a few attendees logging on, and then we'll dive right in. All right, so before we get started, we do just have a couple housekeeping items. Just a reminder to please stay muted throughout the training. There will be a chance to ask questions using the Q&A box. So if you do have questions, please enter them into the Q&A instead of the chat, and then we will be able to answer those. We'll answer some questions live, and others will answer through the Q&A function. If we don't get to everyone's questions during this session, we will make sure to get back to you. Yeah, so this call is being recorded. Following the training, we'll be able to share this out. If you object to being recorded, we just ask that you do disconnect from the session and reach out to us so that we can work out another way for you to get this information. But any questions you ask will be captured as part of the recording. Okay, so thanks everyone for taking the time to be here. This is a training on the ERAP program, the Emergency Rental Assistance Program, and the new direct payments to tenants policy that we went live with at the end of June. So I'll start by introducing your training team today. We have a whole team ready to field questions and present this content. I'm Amy Mullen. I'm a program director at DHCD overseeing the RAFT and ERAP programs. I'm joined by Roberta Rubin, DHCD's Chief Counsel, Amy Steitley, DHCD's Chief of Programs, as well as Rosalind Presswell, the Director of Mediation Programs at the Office of Public Collaboration. And we're also joined by a team at Accenture, who is a consulting firm supporting DHCD with the rollout of these federal funds. So during today's training, we're going to cover an overview of the ERAP program, the Emergency Rental Assistance Program that's federally funded, and then go into the direct payment to tenants policy, as well as criteria and what happens if someone needs to be terminated from the ERAP program. We'll also hear from our partners at Community Mediation to talk with you about the free community mediation resources that are available to you. And of course, there'll be plenty of time for questions during and at the end of the presentation. So again, really purpose is just to review the new direct tenant payment policy that went live at the end of June and to provide landlords with guidance to understand this process. We first just wanted to start with some good news, show you the amount of assistance that ERAP and our other emergency rental assistance programs like RAFT, IRMA, and SHERA have provided since the start of the pandemic. You can see RAFT spending really took off and increased throughout the fall and winter. And then after we went live with the federal program on March 22nd of this year, that program quickly took over as the largest rental assistance program serving households in need during and at the end of the pandemic. As you can see, DHCD, in partnership with many stakeholders and with our regional administering agencies, or RAAs, have been able to serve far more families and households with rental assistance than ever before, serving 14,000 families and individuals this June. So we're going to dive into a few slides that provide an overview of the ERAP program. If you're familiar with the program already, this may be a review. Again, it's been around since March 22nd, but we did just want to put this in context and make sure everyone here understands the federal program first before we talk about the changes with making payments directly to tenants. So the Federal Emergency Rental Assistance Program is a federally funded emergency housing assistance program for renters impacted by COVID-19. It's one of many tools, and our biggest tool that can be used to serve communities in Massachusetts throughout the pandemic. Right now, applicants use our existing RAFT and IRMA application that predated the pandemic. We use that application for all of our programs, so it's one joint application. And the basic eligibility criteria, again, folks have to have a COVID-19 impact, but that can be a direct or an indirect impact. They have to demonstrate that they're at risk of homelessness or at risk of housing instability. They need to be renters. So our other programs like RAFT and IRMA can serve homeowners, but ERAP is for renters only. And finally, they need to have income at or below 80% of the area median income. So this program is serving a higher income population than our traditional RAF program, which is limited to 50% of the area median income. Just a few differences between RAFT and ERAP. Again, both programs continue to exist, but where ERAP has broader eligibility and far more funding, we are serving as many households as we can with ERAP first before tapping into the RAFT program. But again, RAFT will serve homeowners and renters at up to 50% AMI, whereas ERAP is only renters, but up to 80% AMI. RAFT has a dollar limit of $10,000 right now, going down to $7,000 in January, whereas ERAP actually doesn't have a dollar limit at all. Instead, it has a month limit. So we can serve households with up to 18 months of arrears or future rent, as long as those payments were accrued after the start of the pandemic, which for these funds is defined as March 13th, 2020. In addition, although folks can get up to 18 months of total assistance, any future rent assistance is paid 3 months at a time. And the two programs cover really similar kinds of expenses. RAFT covers overdue or future rent, mortgage, utilities, and moving expenses. And ERAP really covers any of those things except for mortgage costs, because again, it is only for renters. So ERAP provides a maximum of 18 months worth of assistance, including any prospective payments or rental stipends up to 3 months at a time. Again, no dollar cap, but the dollar cap is really whatever the monthly contract rent amount is. So again, ERAP can be used for rent arrears due on or after March 13th, 2020. Can't cover more than 18 months of either full or partial arrears. And for renters with an income-based subsidy like MRVP or Section 8, we would only cover the tenant's portion of the rent arrears, not any HAP payments covered by the housing authority or the administering agency. In addition, it can be used on future rent or what we call stipends, 3 months at a time. This is important. If the tenant has arrears, we can't pay the stipends unless we also pay at least a portion of the arrears. But if a household does not have arrears and simply needs help with future rent, that's fine. We can cover up to 3 months at a time of that future rent, even if they don't owe arrears. ERAP stipends, unlike RAFT, actually cover 100% of the household's monthly rent amount, again, 3 months at a time. Tenants recertify every 3 months if they need additional stipends because they're continuing to have a housing emergency related to COVID. And of course, renters with income-based subsidies are not eligible for stipend payments. And that's just because the subsidy payments are already being made by the Section 8 or MRVP administering agency. And so the rent's already affordable based on the household income. So we're not able to further subsidize those renters. In addition, ERAP covers utilities up to $1,500 right now for any arrears dating back to March 13th, 2020, or for delivery if the tenant uses deliverable fuel like oil, propane, or wood pellets. And finally, it can cover moving related expenses that are required to get the person into new housing, such as first and last month's rent, security deposits, movers, or furniture. And again, just a few differences for those with an income-based subsidy like Section 8 or MRVP. They would only get arrears up to 18 months though. They're still eligible for moving expenses and utilities. The only thing is that they cannot get help with stipends. And finally, although we have a joint application for tenants, we actually have a separate application for landlords. So currently, landlords owning up to 20 units of housing in Massachusetts are eligible to apply for assistance directly on behalf of their tenants using the landlord application that's available on each RAA's website. Landlords who don't qualify to use the landlord application because they have more than 20 units or cannot get consent from their tenant to fill out the application can still support their tenants in applying for assistance directly through the tenant application. In addition, qualified landlords of affordable rental housing and local housing authorities can apply for the SHERA program. SHERA is a new program that provides an expedited path for federal rental assistance on behalf of income eligible tenants in housing with long-term project-based use restrictions. And finally, DHCD, in partnership with RAAs, is in the process of implementing a central application. Right now, we have an identical application across 11 regional agencies. In the future, we will have one front door on mass.gov and linked to from the RAA's websites that allows folks to apply directly for statewide assistance. And part of that application will be a universal landlord application with no restrictions on the number of units the owner has. So at that point, an owner with 50 units could apply directly on behalf of their tenant. The timeline for that is September to October of this year with a staggered launch before then. So the application will be going online around the state at different times as regional agencies are turning it on with our support. Okay, so that's ERAP. Now we'll dive into the new policy change on cases where RAAs may make direct payments to tenants instead of landlords. So historically, as with all of our programs under ERAP, we paid, or RAAs, paid landlords directly for any costs that are owed to the landlord, such as arrears, security deposits, and stipends. As of June 28th, DHCD is following federal requirements that require us to have RAAs pay tenants directly for ERAP rental payments that would otherwise be paid directly to the landlord if the landlord doesn't accept the payment. So if the landlord's unresponsive, if the landlord does not cooperate by providing the required documentation, or if the landlord refuses in writing to participate, that triggers the process to start a direct tenant payment that RAAs under the new federal guidance are going to be required to follow. So we want to make sure you all understand this. We'll still be attempting to pay landlords first in all cases, but if a landlord cannot provide the required information or doesn't do it in a timely fashion, we will have to move toward paying tenants directly. There's a few changes with this policy. So the first is with arrears. Arrears payments directly to tenants are going to be limited to a maximum of $15,000. Now, where our program can pay for up to 18 months of rent due since the start of the pandemic, we've seen a lot of tenants with amounts higher than this. So in situations where tenant arrears actually exceed $15,000, if the landlord isn't willing to accept the funds directly, ERAP cannot cover the full arrearage. We'll only pay 100% of arrears above 15,000 if the payment's made to the landlord. So in a case like this, the tenant would get a payment of 15,000, and then if the landlord wanted the balance, they would have to work with the RAA to get that payment made to them directly or get it from the tenant. Otherwise, though, there's no dollar cap on direct tenant payments for other costs like stipends, first and last, or security. We'll cover those in full in the amount that's owed. And again, we're requiring the RAAs and our Supplemental Rental Assistance Processing Center, or RAP Center, to attempt to pay landlords first in all cases. And I'll also just add that eligibility criteria still needs to be met. So tenants still have to prove the amount they owe. They still have to prove eligibility. This is just making a payment to the tenant instead of the landlord if the RAA isn't able to get information from the landlord to make the payment. So the normal guidance for ERAP benefits still applies here. Stipends continue to be capped at the amount equal to the monthly contract rent. So if rent's $1,200, the maximum we'll pay for a stipend is $1,200. Second, stipends cannot exceed 3 months without a recertification. And third, stipend payments are scheduled as they're due. So someone getting assistance now would get help with August, September, and October rent, and those would be paid on or around August 1st, September 1st, and October 1st. Stipends are not paid in a lump sum. And of course, the normal ERAP eligibility requirements that we talked about still need to be met. So we're always attempting to pay the landlord first in all cases, but we do need to move to make a tenant payment if the landlord is either non-responsive or fails to provide required documentation after 7 days to a certified letter, or if the landlord's non-responsive or fails to provide documentation after the RAA makes 3 phone, email, or text attempts over 5 days, or if the landlord at any point confirms in writing that they refuse to participate. So in these cases, RAAs are informing the landlords that payments to tenants might be less than they actually owe because of that $15,000 cap on arrears, and that refusal to participate in ERAP may constitute a violation of state anti-discrimination laws. So RAAs will be communicating with landlords ahead of time. Again, we want to pay landlords and hope that most landlords will continue to participate. But we will be sharing this language with all landlords so that they know what could happen if they don't participate. So this language about chapter 151B will go out to all landlords along with like requests for participation or documents, and lets them know that if the landlord doesn't respond to this communication by X date, which will be the five business days, or refuse to accept the rental assistance, then the agency might make a payment directly to the tenant, although any payment will not exceed $15,000 if it's an arrears payment. And then for RAAs who are communicating with landlords by text, they'll just use the shorter paragraph, but with the same basic information. So every RAA is making at least 1 phone attempt. So those 3 attempts they have to make over 5 days, at least 1 will be by phone. They can also text or email to try to, contact the landlord in whatever manner is easiest for the landlord. If the tenant doesn't have email or phone information for the landlord, or if the voicemail is full, then we're asking them to send a certified letter. We think with the delays in the mail and the costs associated with a certified letter, we're going to try phone, text, and email first, but if they can't do that, they'll be sending a certified letter. If the landlord is not responsive over 5 days or confirms they won't participate, then the RAA will move to some of our new due diligence processes. These are just due diligence on the part of the RAA to make sure that this tenant, is really going to use the money to pay the landlord, and that they understand the consequences for not doing that. So we do require a face-to-face meeting between the tenant and the RAA. This can be virtual or in person, as RAA's offices are starting to open up. We require the RAA to do a public records check just to make sure that the landlord that the tenant listed on their application is actually the owner of that property, to make sure we're contacting the right person when we make all these attempts. And if the tenant comes back after being approved for more assistance, we're asking the REAs to try to reach the landlord again, because again, we want to pay the landlord whenever possible. In addition, REAs are signing tenants are signing a terms of funding agreement letter that DHCD has created that outlines the expectations and the rules for using this payment. We'll talk about that in a second, but REAs have to give a copy of this letter to both the tenant and the landlord before they can make the payment to the tenant. So the letter really just goes through what the tenant's responsibilities are. Namely, if they go to make a payment to the landlord and it's not accepted, they have to return the payment to the REA. They cannot keep it, even if they're going to use it for other housing costs, they're not able to do that. They have to return it to the REA, and then they could potentially get a new payment for other housing costs, like moving costs, if they're choosing to move. So if the tenant doesn't pay the landlord within 30 days, they also have to return the funds. And we are asking all landlords to provide receipts for these payments to the tenant, because our auditors may be looking for receipts after to confirm that the tenant did the right thing with the money and paid their landlord. The terms of funding agreement letter also includes the amount of the payment, the address, what it's for, and a sample receipt in case the landlord doesn't normally give receipts for their payments. So the purpose of this letter is really just to formalize the agreement with the tenant, make sure they know what they're responsible for, and make sure that the landlord knows what's going to the tenant. So as a landlord, getting a copy of this letter is how you'll know that your tenant's been paid and in what amount, and that they have to give the money to you within 30 days. So again, we're requiring landlords to give receipts to the tenants, requiring the tenant to return the payment if the landlord doesn't accept it, or if they just don't give it to the landlord. And we're also giving landlords the opportunity to contact the REA to report delinquency if they don't get the payment in the allotted time frame. And of course, landlords would have the right to begin eviction proceedings for non-payment of rent if the tenant does not make the payment. The letter also spells out that landlords must return to the REA any duplicate payment of rental assistance, as with all of our programs. If the tenant or if the landlord received funding from, for example, the city of Boston for arrears, and then DHCD paid the tenant for those same arrears, the landlord would need to return the duplicate assistance. Okay, so let's move on and talk a little bit about termination. So we hope this won't happen often, but say a tenant does not use the money appropriately and doesn't pay the landlord. If the landlord contacts the REA and says, I got this letter, it said my tenant was getting $15,000 on July 1st, and now it's August 1st and I didn't get a payment, the REA will immediately send a termination of assistance letter to both parties. The letter will explain that the payment was made, but that there's been a dispute over whether the landlord was paid by the tenant, and so all ERAP will be terminated. Gives the tenant the option or the opportunity to avoid termination if they return the payment to the REA within 7 days, or if proof of payment's provided. If the rent remains unpaid, of course, the landlord has the right to evict. Tenant does retain the right to an administrative review at the REA, it's sort of like an appeal to REA leadership. And then DHCD will be reviewing cases of violations and determining whether to refer the matter for criminal prosecution or civil penalties. And so this is the process just for REAs. If they get a call from the landlord saying that the payment wasn't made, we're asking REAs to check to see if it's been 30 days since the agreement was signed. If it hasn't yet been 30 days, they do, the landlord should wait until day 30 and then can report at that time. If it's been over 30 days, that's when that termination letter would go out. REAs would then stop any future payments or stipends and terminate all future eligibility for the ERAP program for as long as it exists. And then if either party appears to have participated in any kind of fraudulent conduct, RAs are under instruction to contact our fraud hotline, and we'll make the decision whether to investigate or refer up to, you know, the relevant parties. So that is it on ERAP direct tenant payments. I'm not sure if we have questions we want to answer now in the chat, or if we should move on to community mediation.
Amy, we don't have any questions yet in our chat, but this would be a good time if you do have them to go ahead and get them posted, and we'll turn it over to Rosalind Cresswell, who can tell us more about community mediation, and we can circle back to questions in a few minutes.
So hi, everyone. I wanted to give a very brief overview at a pretty high level about what community mediation is, which is one of the offerings through the Governor's Eviction Diversion Initiative. So to start off with, as I say, a very, very high level overview, and I'll take questions afterwards if people have them. So what is mediation? Mediation is a voluntary and confidential process facilitated by a neutral third party, who is the mediator, who prioritizes self-determination and informed consent of the parties to reach a mutually agreeable outcome or process towards one. To make that much easier to understand, because the language is very formal, basically everybody who takes part in it has to be willing to do so. The process is not recorded in any way, and information that's given in it cannot be subsequently used. The mediator helps the parties have a conversation together and figure out a way that works for both of them to resolve the particular issue that's between them. Unlike going to court, where you would go and present your case and then be given judgment by the court, this is an opportunity for people to be able to decide what that outcome should be for themselves. It's not an adjudicatory process, again, like going to court, so the mediator doesn't take sides, they don't make recommendations, and they don't direct parties to a particular course of action. And it's also not, although it's called mediation and implies somehow meeting in the middle, it's not necessarily about meeting in the middle. It's about, as I say, finding a way for the parties to find out what's most important to them and how they can achieve it with a conversation helped by the mediator. Okay, next slide, thank you. So when should you access mediation? So the answer is really any time is suitable. The best time as soon as there's a problem. So before people get too entrenched in their positions or escalated or upset about the situation, as long as you know that there's something going on that needs working out between a landlord and tenant, it's a good time to reach out to a mediation program. You can then also reach out to us prior to filing a notice to quit. So maybe you've been trying to work something out on your own, and rather than going to the expense of filing in court and the implications from the tenant of potentially having a judgment against them, you can also contact us prior to filing that notice to quit. There'll then be a gap in time between filing the notice to quit and the actual hearing date. Another good opportunity to come to us. As I say, that's a final chance to build in those kinds of flexible outcomes and also to be able to access any resources that may not be available on the day of trial. Your case will be managed by a case manager who can refer you on to legal advisors or to people for financial assistance as appropriate. On the actual day of trial, there may be mediators available in the court. It depends what type of process you start. Our programs are available through all district court filings. So again, on the day, you'll be offered an opportunity to go to mediation, which will give you some say over the outcome and how that works for you. And then finally, after the court hearing, there may still be outstanding issues. If you filed around a particular single issue, there may still be ongoing relationship issues or communication problems or behavior issues, which also need to be worked out in addition to any kind of a court judgment. And that's also an opportunity when you can reach out to the local mediation centre to see if they can help you work those out. So why should you choose community mediation? Well, first of all, it's free and it's a much faster alternative to court action. Some survey results, we do constant evaluations of our program. 100% of the participants who we've surveyed thought the process was fair. And we've been handling a lot of cases over the last 6 months. There's a high rate of success. So amongst the cases that have been mediated, there's been a settlement rate of nearly 80% of all those cases. There's no tenant income eligibility or landlord income eligibility for access to services. It's available to all community members. And as I've said, at any stage in the process where you are, it allows for flexible and creative outcomes. Over 95% of people were satisfied with how their problems were handled. And it can allow people to talk about anything that's important to them on the day when they mediate. So again, if you've focused on a particular issue of non-payment, there may be other issues that you can bring into the mediation conversation, which you can resolve at the same time. And can help with ongoing communication and relationships, as I've said earlier. We've been talking to mediation participants, and this is a quote from a particular landlord who says that they would certainly come back to using mediation again rather than going to court. How can you reach us? So at the moment, mediations can be held either by phone, online, via Zoom, or in person at some centres, or through the court system if you've already filed. You can find out more information about how to access your local centre at the website link here, resolutionma.org. That gives contact information for all the centres. We have 12 serving every county in the state, so there will be one local to you, and you can look the details of them up on that website and find out the best way to contact them.
Thanks, Rosalind. That was really great to hear about this great resource that people can access. So we do have questions starting to come in. And so again, if you have questions, this concludes the content from the session. So our first question, I think I'm going to ask Amy Mulland if you wanted to answer, was if a tenant received the maximum wrapped assistance, are they eligible for additional payments through ERAP?
Yes, so yeah, we have lots of folks coming to ERAP who've already used RAFT, have hit the $10,000 limit. They're welcome to get additional assistance through ERAP. They do have to demonstrate that they have an eligible housing crisis so that they're at risk of homelessness or housing instability, but that's pretty broad. That can be they owe arrears, can even be that they can demonstrate that they can't pay their future rent, and they're welcome to get ERAP up to 18 months. We just can't cover any of the same costs twice, of course. And so if someone got, for example, half of their rent paid through RAFT in July, we couldn't pay all of their rent in July through ERAP because they don't owe that much. But people can kind of layer the funds, and there's no restriction on using ERAP if they already got one of our other programs.
Thanks, Amy. So our next question, I'm going to send over to Roberta to answer. So the first slide titled Termination of ERAP Benefits, the last bullet said that DHCD will review payment violations for referral to criminal prosecution or civil penalties. Will DHCD be making such reviews for civil referrals when landlords refuse to participate in rental assistance in suspected violation of MG Chapter 151B?
Hi, and good afternoon, everybody. So there's been a lot of discussion about 151B and its relationship to the emergency rental assistance. And I know, Doug, you've been very vocal on this point, and there's a lot of folks who are very focused on this. I will personally welcome, a test case at some point, because this is a little bit of uncharted territory. Just to clarify for folks on the phone, Chapter 151B prohibits discrimination based on source of income, and the courts have in the past found that other housing programs, such as the Section 8 program, that is what this applies to. So, for example, a landlord could not refuse to accept Section 8 as a means of payment where they would otherwise accept a tenant if they were paying out of pocket. And the case law goes on to talk about, the fact that there are program requirements does not mean that a landlord can just say no because the money is coming from a subsidy program rather than from the tenant's own funds. And the Attorney General's office has issued some helpful guidance on this point as well. With respect to evictions, I think there's some very clear situations and there's some murky situations. So very clear situation is where, in my mind at least, is where the amount of assistance available is ample to cover the full amount that is owed to the landlord. There are no future strings attached as far as, we eliminated the 6-month forward pledge not to evict. So the landlord, is basically being made whole. There's not a lot of justification for that if the dispute is just about money. And that's where I think Chapter 151B would kick in. The challenge in this area, and where I think we have yet to see how it's going to develop, is where you have mixed motivation for terminating a tenancy, where there is money involved, but there's also been bad acts on a tenant's part that would lead the landlord to wish to evict. And I don't think that we as an agency or our administering agencies have a great mechanism for distinguishing between those. With that said, I think we will probably be in close contact with the Attorney General's office over the coming months. And if there were an egregious situation where this was clear, yeah, I think we'd be in touch with the Attorney General's office to say, hey, this looks to us like it might be a 151B violation. You might want to take a look. By the way, just to clarify, I had mentioned a 6-month policy. I want to be clear that there is no 6-month policy under ERAP at this time. There had been one under RAFT several months ago, and as I hope the folks on this call know, that was eliminated. We do have some requirements under the SHIRA program, but that's not relevant to ERAP.
Thank you so much, Roberta. Amy, I think this question you'll be suited to answer, but is a tenant able to apply for ERAP? And is the funding able to apply to rent arrears even though they have already moved out?
Yeah, so if someone's experiencing a housing crisis, and we see this mostly with people who are doubled up or homeless and looking to move into new housing, we can also cover rent arrears for their preceding unit. So the place that they lived immediately before they became homeless.
Thanks, Amy. So if you have questions, again, please post those in the Q&A. We'll wait a few seconds to see if we get any more, and we can then talk about where you can find these materials and some other resources available.
Okay, so we'll talk about some of the resources, and still, feel free to add additional questions in the chat as they come up. We want to continue providing support and information beyond today's session. So there are some resources that you can keep an eye on and visit as you need more information. First, you can visit the DHCD landlord landing page that has information on ERAP. In addition, we are recording this session. We'll be sharing the recording on the EDI portal. And then finally, we've included the link to community mediation that Rosalind spoke about. You can get information about community mediation at that link. So thank you everyone for participating today. I don't know, we can stay on maybe for a few minutes longer and see if there's other questions that come up. Stay on for a few minutes, but otherwise we just really thank you for joining us today. Hopefully this information is useful for you and your tenants, and we look forward to continuing to partner with all of you.